Welcome to the Deep Dive. Today we're going to tackle a really common point of confusion for business owners.
Yeah, it's about how trusts mesh, or sometimes don't mesh, with owning C-Corp and S-Corp.
Exactly. It can feel like a minefield, honestly.
Mm-hmm.
And, well, we want to help you navigate it.
We've been digging into some helpful stuff from places like LegalZoom, BDO, UpCounsel.
Davis Wright Tremaine, the Corporate Finance Institute. Quite a bit of reading.
Right, so we've tried to distill it down. Think of this as, getting the essentials without wading through all the legalese yourself.
Our goal here is pretty simple, really.
Oh.
We want to clear up how trusts actually work when it comes to owning shares in C-Corp versus S-Corp.
And crucially, point out some of the big pitfalls, the things that can really catch you out if you're not careful.
So let's dive in. Where's the best place to start with this?
I think we got to start with the fundamentals. Like, what's the basic difference between a C-Corp and an S-Corp when it comes to who can actually own the thing?
Good point. Because that ownership difference is sort of the root of the whole trust issue, isn't it?
Absolutely. So think about C-Corp first. They're generally much more flexible.
Right, like an open-door policy for shareholders?
Pretty much, yeah. Individuals, sure, but also other companies, even foreign investors, can own C-Corp shares.
And importantly for this conversation, trusts. Any kind of trust.
Generally speaking, yes. C-Corp don't really have strict limitations on the type of entity that can be a shareholder. So a trust owning C-Corp stock, usually not a problem.
Okay, so C-Corp equals flexibility and ownership. Got it.
Now, flip over to S-Corp, it's a completely different story, much tighter rules.
Like a members-only club, you said before.
That's a good way to put it. The IRS has very specific rules about who qualifies as an S-Corp shareholder.
And this is where trusts really come under the microscope.
Exactly. Only certain types of trusts are allowed to hold S-Corp stock. Not just any old trust will do.
And if you mess that up, if the wrong kind of trust owns S-Corp shares.
Big consequences. The big one is that the company can automatically lose its S-Corp status. Just like that.
Whoa. Okay. And losing S-Corp status means?
It means the business defaults back to being taxed like a C-Corp.
Ah, and that brings us to the dreaded double taxation possibility.
Precisely. The corporation pays tax on its profits, and then you, the shareholder, potentially pay tax again when you receive dividends. It's often something people choose S-Corp status specifically to avoid.
Okay, so understanding those basic ownership gates, C-Corp flexible, S-Corp restricted is like step one.
Absolutely critical. It sets the stage for everything else.
So let's clarify. Trusts can own shares in both types of corporations, right? It's not forbidden entirely.
Correct. They can own both, but the rules are drastically different.
For C-Corp, as we said, pretty straightforward. A trust wants to own shares, generally fine, no special type needed.
Yep, that flexibility carries through. But S-Corp, that's where you need the right credentials.
The specific membership card, so to speak. Which types of trusts actually make the cut for S-Corp?
Okay, so the main ones you'll hear about are, first, grantor trusts. These are often like typical revocable living trusts while the person who set it up is alive.
Okay, grantor trusts. What else?
Then you have QSSTs, that stands for Qualified Subchapter S trusts.
QSSTs. Got it.
And the third main type is an ESBT, an electing small business trust.
ESBT.
Okay.
Okay, grantor, QSST, ESBT. Those are the key ones.
Those are the big three, yeah. One of the sources, I think it was UpCounsel or BDO, also mentioned testamentary trusts.
Trusts set up through a will.
Exactly. Those can sometimes qualify, usually for a limited period after the person passes away, but again, specific rules apply. It's not automatic.
Right, so it's a very defined list. You can't just assume your family trust qualifies.
Definitely not. Assumption is dangerous here.
Okay, so why bother then? If S-Corp is so picky, why would someone want a trust to own the shares anyway? What are the benefits?
That's a really important question. There are actually some very good reasons. Asset protection is a big one.
How does that work?
Well, if the business shares are held within certain types of trusts, they might be shielded from, say, future personal lawsuits or creditors of the beneficiary. It adds a layer of protection. UpCounsel mentioned this specifically.
Makes sense. Protecting what might be your biggest asset.
Exactly. And another major benefit is business succession planning.
Ah, planning for the future. Passing it on.
Right. A trust can lay out very clearly who gets the business, when, and under what conditions. It can make that transition much smoother, much more predictable than just leaving it in a will sometimes.
So, definite upsides. But it brings us back to that danger zone. S-Corp and trusts that aren't on that approved list.
Yeah, this is really the crux of the potential problem. Using an ineligible trust, It's like stepping on a tax landmine you didn't even know was there.
And we said it before, but it's worth repeating. It can automatically blow up your S-Corp status.
Automatically. You might not even realize it happened until the IRS points it out, potentially years later, with back taxes and penalties.
And that consequence, defaulting to C-Corp taxation, the double tax risk that can seriously hurt the business financially.
Hugely. It can wipe out a significant chunk of profit that would have otherwise flowed through to the owners.
You mentioned living trusts earlier. That seems like a common area for confusion.
Yeah.
Davis Wright Tremaine flagged this, right?
Yes, precisely. Lots of people have revocable living trusts for estate planning. They're very common.
But just because you have one doesn't mean it's okay for holding S-Corp stock.
Not necessarily. A standard revocable living trust typically only qualifies as a grantor trust while the grantor, the person who set it up, is alive.
Okay.
After the grantor passes away, that trust might cease to be a grantor trust. And if it doesn't convert or qualify as a QSST or an ESBT within a certain time frame, boom, you've got an ineligible shareholder.
So even a trust that was okay initially could become a problem later on.
Absolutely. Or if it wasn't structured correctly from the start to meet the QSST or ESBT requirements, it might never have been eligible even if it was a living trust. It must be one of those specific qualifying types.
Wow. That's a detail that seems easy to miss. So why all these hoops for S-Corp? Why does the IRS care so much about the type of trust?
Well, it boils down to the tax benefit, really. S-Corp status allows profits to pass through directly to shareholders, avoiding that corporate-level tax.
Right, the pass-through taxation.
The IRS wants to make sure that this significant tax advantage is only used by the types of owners and structures originally intended by Congress. These rules, especially around trusts, aim to prevent complex ownership structures that might, obscure who's actually benefiting or potentially game the system.
So it's about maintaining the integrity of that pass-through structure.
Essentially, yes. Making sure the benefit flows to clearly identifiable individuals or specific types of approved trusts that have their own set of rules.
Okay, this is super helpful. Let's shift to practical steps. What should someone listening right now actually do?
First things first, know your entity. Are you a C-Corp or an S-Corp? You absolutely have to know this for sure.
Sounds basic, but critical.
Foundational. Then, if you are an S-Corp and you either have a trust as a shareholder now, or you're even thinking about transferring shares to a trust,
Yes.
you must figure out the exact type of that trust. Is it a grantor trust? Is it designed to be a QSST, an ESBT?
How do you figure that out?
Get the trust document itself, the actual legal agreement. You, or more likely, your advisor needs to read it carefully.
Look for those key words, right? Grantor, QSST, ESBT.
Exactly. The language in the document defines what type of trust it is and whether it meets the IRS requirements for S-Corp ownership. Don't just rely on the name someone casually calls it.
And this sounds like a point where you really, really need professional advice.
Oh, absolutely. Non-negotiable, I'd say. Talk to a tax professional, a CPA, an enrolled agent, or an attorney who really knows business structures and trusts.
And do this before making changes, right? Not after.
Please, yes. Get advice before you transfer any S-Corp shares to any trust. They can review the trust, tell you if it qualifies, or advise on how to set up a trust that does qualify, or if modifications are needed.
It's like preventative medicine for your business's financial health.
Exactly right. Far cheaper and less stressful than dealing with the IRS after a mistake has been made.
Anything else to keep in mind?
Well, remember that rules can change. IRS regulations aren't static. So staying generally informed is important.
And maybe doing a periodic checkup.
Yeah, that's a good idea, especially if your business grows or you bring in new owners or maybe circumstances around the trust change, like a grantor passing away. It's wise to periodically review your ownership structure with your advisors just to make sure everything is still compliant and aligned with your goals.
Okay, let's try and wrap this up. What are the absolute key takeaways here?
Okay, takeaway number 1. C-Corp are flexible. Trusts can generally own shares without too much fuss.
Takeaway 2, S-Corps are strict. Only specific trust types, grantor, QSST, ESBT, primarily are allowed as shareholders.
Takeaway 3. The biggest mistake is using the wrong type of trust for an S-Corp. That can lead to losing your S-Corp status.
And facing potential double taxation, a costly error.
Definitely. So takeaway 4 is know your structure, C-Corp or S-Corp. Know your trust type if you have one, and
Get professional advice. Talk to tax pros. Talk to lawyers before you act, especially with S-Corp.
couldn't stress that enough.
All right, so here's something to leave you thinking about. Look at your long-term plans. Where do you see your business going? Think about succession, maybe bringing in investors down the line.
Yeah, how does your current structure, C-Corp or S-Corp, and these trust rules we've discussed, how do they fit with that future vision?
Are they helping you get there, or could they potentially create roadblocks later on? Understanding this stuff now can really help you build on solid ground.
Well said. It's about being proactive.
Thanks for diving deep with us today.